Finally, we get another great cross-examination of a murder defendant. And I thought this one was really good. Hi, folks. Tony DeWitt again with another video on the law. Remember, I don't dispense legal advice here, and this is what we're talking about today. It hasn't been since Creighton Waters took Alex Murdaugh apart on the stand, deftly applying the scalpel instead of the broad axe to him, that we have seen a good cross-examination of a murder defendant. And in this case, we see a good cross-examination of the murder defendant. We're in Colorado for the Colorado versus Rodriguez trial. That is the case where a woman is charged with homicide for uh, the man that she was living with, and uh, also with arson for burning down the place where he was living because she had allegedly killed him. And in fact, now she has testified that she in fact did kill him. So it's an interesting cross-examination because the theory behind her defense is that it was self-defense. So before we get into the actual cross-examination, let's talk a little bit about self-defense. In self-defense, you have to have certain things. One of the things that you have to have is an imminent deadly threat. In other words, somebody has to be actively working at harming you physically such that you would suffer great bodily injury. We're not talking about, a dislocated pinky here. We're talking about, injuries that could put you in the hospital. You have to have that imminent deadly threat. Usually, it's a weapon, a knife, a gun, a rope that somebody's going to strangle you with, or their hands around your neck, strangling you, those kinds of things. An imminent deadly threat. The second thing you need to have is a reasonable belief that it's necessary for you to use force in order to defend yourself. Well, when would it not be necessary to use force when someone was threatening or possibly coming at you to cause harm? When you could simply step outside the door and leave. That's one way. Now, you don't have to in most cases, particularly if you have a stand your ground law, and Colorado does have such a law. But at the same time, the threat has to be imminent, it has to be deadly, and the amount of force you use has to be commensurate with the degree of harm. So if someone is punching you, you can't pick up a ball bat and bash their head in. That's just the way it is. And also, a reasonable belief is different from a subjective belief. A subjective belief is something you have. I believe it was absolutely necessary to protect myself from that butterfly to use a shotgun to shoot it down, right? That's my reasonable belief, but that's a subjective belief. Nobody else would think you'd ever use a shotgun to take down a butterfly, for heaven's sakes. A reasonable belief is something that other people would have in the same situation. So there is a big difference between this subjective belief and the reasonable belief. And in this particular case, that is something that's coming through pretty loud and pretty clear.
Do you have enough water, ma'am?
Thank you.
Do you understand why we're here?
Yes.
Objection relevance.
Objection relevance? Really? That's what you're going with? All right. If she doesn't understand why she's there, then they're going to have a really hard time convicting her because she's not competent to stand trial. There's absolutely nothing wrong with that question. But if you start objecting early, you communicate to the prosecutor, I'm going to try to ruin your rhythm. And of course, the prosecutor has been down this road before. He knows what's going on here. He just plows straight ahead.
I'll overrule the objection.
You do?
Yeah.
Do you understand that we're here because of Christopher Dickerson?
Yes.
If we could show Exhibit 1. That's him, right?
Objection sympathy.
That's another ridiculous objection. Sympathy? How is showing a picture of the person who was killed a request for sympathy? Now, if they showed him with all of the wounds and all of that kind of stuff, or made her confront what it was that she did in some grotesque way, yeah, I can see where you might say that they're trying to get sympathy from the jury. But this, she's probably got a list of objections to make. I don't know. The sympathy sure as heck wouldn't be one of them. And there's no point in objecting to the picture of the person who was killed. Everybody understands that that's relevant.
All right, I'll overrule the objection.
Do you get that's why we're actually here, ma'am?
Yes.
Do you get that we're not here for your toxic DV relationship?
Objection, argumentative, and relevance. Asked and answered.
Okay, she finally hit one there. It is argumentative to call it a toxic DV relationship. And again, it always makes me laugh when people think, well, okay, she's not going to have to answer that question. Whew, boy, that saved her. No, it didn't. Because the problem for the defense in this situation is the jury heard the question. So now, having objected to it and having that objection sustained, they know that a truthful answer to that is probably going to hurt the client. So again, you have to be fairly judicious on cross-examination about your objections. The argumentative part, absolutely, it was argumentative. But asked and answered, no, that's not going to fly here. And relevance, again, not going to fly here. Like I said, she's just basically trying to interrupt the flow for the prosecutor.
I'll sustain as to argumentative. If you want to rephrase, Mr. Praler, go ahead.
Do you understand that we're here for your actions?
Objection, asked and answered.
I'll overrule the objection.
Yes.
Do you understand that we're here specifically for your actions of plunging that weapon in his neck
Yes.
5 times?
Yeah.
You understand that?
Yes, sir.
Objection, argumentative.
Overrule.
And now you're saying that we're here and you want to explain a lot of things because of your social anxiety. Did I get that right?
Yeah.
Social anxiety. Can you explain what that means?
Well, she can't explain it, but I can. Social anxiety disorder is an intense, persistent fear of being watched and judged by others. This fear can affect work, school, and other daily activities. It can even make it hard to keep friends. The good news is it's treatable. But here's the issue. When you listen to her answer about what is social anxiety disorder and where it was, what you find out is that she doesn't really suffer from social anxiety disorder. She suffers from a fear of being convicted of murder. And that, I think, is a pretty reasonable fear on her part.
Just anxiety do you get when you're social?
Okay.
You're supposed to be
So you
social.
want to avoid social settings, right?
Yeah.
Where was your social anxiety on October 11th when you denied knowing him to a police officer?
I don't know.
I don't either.
Objection, is there a question?
There was a question, Mr. Praler. I'll sustain to your statement.
Do you know
Just
where
ask
it's at?
questions, please.
It was there.
It was there.
Yes.
We just don't see it in the video.
Now, are you noticing how the defendant here is doing this, ringing back and forth? And if you look closely in between questions, she's pressing her lips together like this. Can't see it because of my mustache, but look at her lips. She's pressing her, those are self-soothing behaviors. And it's almost like she's trying not to fight with the prosecutor here because she knows this guy is out to get her. And frankly, because he represents the state, I'm kind of glad he's out to get her. I don't want people running around plunging knives into people. And I'm pretty sure most normal people don't want that. But it's interesting to watch her move back and forth. She is telegraphing to the jury, again, holy cow, I don't want to have to do this. But when you testify, you have to face cross-examination. And this isn't going to be good for her.
Fair? I mean, you just admitted to her that it looks on that video like you don't care, right?
Yeah.
Okay. And in that social anxiety situation, you denied knowing Christopher.
Yeah.
You denied seeing him,
Yeah.
being at his house.
Yes.
Stabbing him.
They didn't ask me that.
Okay. Well, you were told of your charges, right?
Your Honor, we'd have asked to take down this exhibit at this point.
All right, I'll overrule the objection.
You were told of your charges, right? Of first-degree murder,
Yeah.
arson, burglary, and tampering with a deceased body. And you had social anxiety, right?
Yeah.
And you responded with, is there proof of that?
Now, bear in mind, she has already admitted to having killed this man. And now she basically it's pointed out to her that, you denied doing this. You denied a bunch of stuff. You didn't even know the guy. And yet you're saying this. And then you ask if there's proof. That's the kind of thing that indicates your intent when you set the house on fire to set the house on fire. There's no proof. Well, sometimes the proof comes in the way you acted after the crime, not necessarily before the crime. So, again, a great question by the prosecutor there.
Yeah.
To a police officer, right?
Yeah.
Now, let's jump forward a little bit and see what's happening a little bit later on in the cross-examination.
Well, ma'am, there were a couple notes in opening statements, right?
Yeah.
Like a note to flush.
Yes.
Had you ever gone over that with counsel prior to that opening?
I mean, I just told them that I didn't write it, and that was that.
Okay, and that didn't answer my question, so I'm going to ask you to go back. Did you review that prior to me getting my screen up to come up for opening statement?
Yes.
You had reviewed it?
Yeah, discovery.
Okay. Do you remember that aspect of the delay in the opening because there was the argument that that note hadn't ever been discovered?
Objection, can we approach?
All right, can the parties approach?
Now, again, it's not going to matter what the ruling is here or what even the rebuke is, if there is one, because the answer to this question is not important. What's important is that he's calling to the attention of the jury. Remember in opening statement how they threw this complaint and made it look like we weren't playing fair by keeping this information from them and they had it all the time? She even just admitted to having gone through it with the discovery. It does a couple of things. It tells the jury, one, you can't trust that defense attorney over there. And two, it tells them that this information, that note, really, really hurt them. So I think it's really important that when you're doing something like this, that you make that point. This is going to come back out in the closing argument. I'm absolutely certain of it.
And then ultimately, really where this comes back, it diverges once you get back to the place, right?
Yeah.
And ultimately, in the end, and we'll talk in more detail, you would agree that no one stabbed Mr. Dickerson other than you,
Yes.
right? I mean, Hosanna didn't,
No, I said that.
okay? And you would agree that when his phone's going all these places after the fact, he's not alive, right?
No.
Okay? And he didn't tell you in his last dying breaths, hey, take this ring, take this phone, right? He never gave that to you. And then you agree that Hosanna goes out and gets into the car before you, right?
Yeah.
You know all those details. Fair?
Yeah.
And you agree with all that. Fair?
Mm-hmm.
You agree that you come out minutes later and actually get into the car.
Yeah.
You agree that you drove to this gas station.
I didn't drive, but I sat passenger seat, yeah.
Thank you for that clarification. You guys go to that gas station.
Mm-hmm.
Gas is purchased. You return to Mr. Dickerson's house. He was dead at that point, right?
Yeah.
You agree that you're the only person who actually goes in.
Yeah.
You would agree because he's dead, he can't give you permission to go in.
Yeah.
And Ms. Rodriguez, you have to answer out loud.
Yeah.
You agree that you go inside and you start the place on fire.
Yeah.
You agree that when we look at those photos of Chris, that's because you burnt him,
Yeah.
right? And then you agree that you go back to your brother's house and you switch to get into the Tahoe, right?
Yeah.
Okay? All those things you agree with.
Yes.
This woman is very nervous. She's very scared. She's pounding in the water. I'm sure she's going to need to take a bathroom break pretty quickly. And she just admitted to all of the key facts in the prosecution's case. Now, keep in mind that you can have self-defense as to the homicide. That would make it justifiable. But the arson, there's no self-defense exemption for arson. There's no self-defense exemption for destroying the evidence. There's no self-defense exemption for, misuse of a corpse, so to speak. All of these things she has just admitted. She is going to be convicted. The only question is going to be whether she had a reasonable belief that she was in imminent harm because they were basically tussling on the floor. He wasn't strangling her. He wasn't shutting off her air. He wasn't punching her. He wasn't hitting her. She was kicking him. He was trying to get away from her, apparently. And according to her testimony, she didn't even look when she assaulted him with a knife. And and also, I would point out that she didn't, call for medical help after that. She didn't try to do anything to save his life. And at least when, one of the things that I do is I teach people how to react if they have to use a firearm in self-defense. I do that because I think that's an important thing for a lawyer to do. I teach that course. And when I teach that course, I say the first thing you have to do is call 911, and you have to tell them to send medical. You tell them to send medical and then send the police, because human life is precious and you want to make sure that the person that you have injured is not going to pass away. So you ask for medical. Thus, even in a self-defense situation, you try to get aid for the person who attacked you. But in this case, she not only didn't try to get aid for him, she basically allowed him to die, and then she tried to destroy the evidence by setting the house on fire. You can tell by the way she's moving back and forth, by the way her lips are pressed together, by the way yeah, yeah, that she really doesn't understand the import of what she's communicating to the jury, which is, yeah, I did it, and I'm not sorry about it. And I don't care what anybody thinks. I felt like I had the right to do this, and I did it. That's what's coming across to the jury. Now, what the jury does with that, hard to say. And the prosecutor here can't be too over the top. And a couple of the things that he did were pretty close to that line. But he can't be too over the top, because if he is too over the top, then if there is anybody on the jury who has been the victim of domestic violence, or has a friend who's been the victim of a domestic violence incident, or has some other, belief that somehow all women should be believed and it doesn't matter how ridiculous the story is, you should fall on the side of protecting women. And frankly, that seems to be a very popular opinion right now, and Colorado is a very liberal state. It might be a good theory to advance in the closing argument. But right now, she is not making any friends with this jury with this testimony. So that's what I have for you today. Thank you so much for watching. If you would like, you can disagree, drop a comment telling me you disagree. Otherwise, come on back, catch me down here tomorrow. Thanks for watching my video. If you have a request for me to cover a topic, please send me an email to the address above, and in the subject line put video request. If you have comments, drop them in the comments down below. If you found the content worthy, please consider subscribing. Since I started doing this work, I have always asked listeners to consider doing just one kind thing every day to make somebody else smile or make their life better in some way. Please consider doing that. It makes the world a better place. Now, YouTube has some suggestions for other videos of mine you may find interesting.